At the time the former minister was making a budget vote speech in May 2016, it was unlikely that she did not appreciate the fact that Sassa would not have been ready to take over the function. In light of the above, it is prudent to mention that it was widely reported in the media that the former minister had known since July 2015. But then in our investigation, we then discovered that the allegation that the minister deliberately misled the National Assembly when she delivered her budget vote speech, in which she made an undertaking on behalf of Sassa to take over the management and control of the payment process that was performed by Cash Paymaster from April 2017, and in doing so violated the code, could not be substantiated. In the matter between Black Sash Trust versus the Minister of Social Development, Froneman J. held in his judgment that since April 2016, the responsible functionaries of Sassa have been aware that it could not comply with the undertaking of the Constitutional Court, that it will be able to pay the social grant in 1 April 2017. However, confirmed that the former minister only became aware of Sassa's inability to make such payment in October 2016. So even though I did not make any findings against former Minister Dlamini on the violation of the code, I think we all know that there is a Constitutional Court judgment already on this particular matter where they pronounce that the minister might be liable for the cost of application in her personal capacity and official capacity. Based on the information and evidence obtained during the investigation, I could not make any finding on the allegation that the former minister deliberately misled the National Assembly or contravened the Executive Ethics Code, especially because of her response during that particular period. I now move to other reports in which we made findings. I must mention that the bulk of the reports I'm issuing today involve emerging as a widespread problem across all spheres of government, including statutory bodies. Increasingly, my office finds itself having to deal with allegations of appointment of staff without following the recruitment policies, which makes it clear that vacancies should be advertised. There should be a shortlisting process, interviewing of candidates according to the adverts, and so that they can appoint deserving candidates. Unfortunately, in many of these investigations which have been brought to our attention, these rules have been flouted, and we have seen this in the previous reports I've issued, the City of Tshwane report, the Northern Cape Liquor Board, the South African Weather Services, all of which I issued earlier this year. But now again, there's still that repetition which we are picking up as an institution. The first one relates to the Gauteng complaint which was lodged by Mr. Mphahlele, the allegations of maladministration against the erstwhile Westonaria local municipality, which is now known the Rand West local municipality. So the complaint arose from former municipal manager, Mr. Ndlovu's alleged payment of overtime benefits to a seconded CFO, Ms. Khumalo, and his alleged appointment of Mr. Njingolo as senior manager strategic services without following proper procurement services. So in this matter, there was a finding that all this investigation, there was a substantiated claim, and the remedial actions which I have directed are that the council should be, within 60 days, take appropriate steps to recover the irregular expenditure by the former municipal manager, and further as well, the council should institute civil proceedings against this Mr. Ndlovu because he's no longer working for the council. The second one relates to a complaint by Mr. Berg about the alleged maladministration and irregular appointment of one Mr. Anthony Melder the divisional head, maintenance, and the irregular awarding of tender by the Ekurhuleni Metropolitan Municipality. So it was alleged that the municipality advertised a vacant position of divisional head maintenance, road and stormwater. It was also alleged that Mr. Melder was appointed as the successful candidate even though he did not submit an application for the vacant position and was not shortlisted. And further, there was an allegation that Mr. Melder was apparently promised the position by Mr. Kokoi as per the instruction of from the ANC, and he further alleged that there was maladministration and tender irregularities by the municipality for the upgrading and construction of roads and stormwater infrastructure. Following the analysis of the evidence and the complaint, we determined 4 issues, which is whether the municipality irregularly appointed Mr. Melder to the position, and whether the municipality irregularly awarded the tender, and whether there was an irregular escalation of the tender amount, and whether the appointment of Mr. Melder and issuing of the tender prejudiced the taxpayers and residents of the municipality. So our investigation found that all the allegations were substantiated, thereby they violated the Constitution and the Public Protector Act. The remedial actions which we've taken include that the municipal manager must, within 60 days of the date of this report, all the irregular expenditure incurred by the municipality in connection with the irregular appointment of Mr. Melder to the position be reported or be disclosed to the Council, Treasury, and the Attorney General. And the Speaker of the Council must ensure that disciplinary processes are instituted against the officials which are involved in the process. And the next one includes the Gauteng, it's an Gauteng office as well, the allegations of irregular appointment of the communications officer and nepotism by the executive mayor of Lesedi local municipality. This was a complaint lodged by Mr. Mkhwebane, and who complained that a certain Mr. Tokwana was appointed irregularly by the municipality. She alleged that the requirements for the post included bachelor's degree or equivalent in communications, journalism, media studies, or any other appropriate field. According to her personal knowledge, Mr. Tokwane was not having these qualifications, and on investigation and analysis of the complaint, we determined the following issues: whether the appointment of Tokwane without following proper procurement processes, whether there was any impropriety in that, whether the appointment of Tokwane resulted into prejudice to the complainant and other complainants. Both the above allegations were substantiated, and we took appropriate remedial actions in the circumstances. That the acting municipal manager must ensure that any irregular or fruitless expenditure incurred by the municipality from any person who's liable in law is recovered, and he must also ensure that the disciplinary processes are instituted to the officials which were involved in the process or the recruitment process. And in addition, he must ensure that all municipal officials who are involved in recruitment and selection processes, including all senior management, attend a workshop on recruitment and selection and related legal prescripts. The next one is an Mpumalanga matter where we've investigated also irregular appointment of one Moses Mahlangu as a senior mechanic in the Steve Tshwete local municipality. This was a complaint lodged by Mr. Siabe. So he requested my office to intervene and investigate the matter. And according to him, the municipality appointed Mr. Mahlangu as a workshop senior mechanic, even though he did not have the qualifications for the post. So in this matter as well, we've analyzed the information on investigation and on receiving all documentation. We found that the allegations were substantiated and constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. So to remedy the matter, the Speaker of Council is directed to ensure that the Municipal Council, in consultation with the Municipal Manager, declare the appointment of Mr. Mahlangu as irregular. The salary of Mr. Mahlangu should reflect as an irregular expenditure in the municipality's financial statement, and this must happen within 30 days. And the Municipal Manager was cooperating with the investigation, and when responding to our Section 7(9) notice, he also provided a plan on how he will be dealing with the matter and taking disciplinary action against the involved officials. The next matter relates to the Mpumalanga province again, with the irregular appointment of a senior manager communications by the provincial legislature. The investigation followed a complaint from a certain Mr. Dom Kosi, who was a former employee of the legislature and a candidate for the position in question. He requested the public protector to intervene and investigate what he perceived as maladministration relating to the appointment of Ms. Memela to the position. He alleged that he participated in an interview for the post. Days after the interviews, he met some of the interview panel members who congratulated him on his new appointment, unaware that he has not been appointed. So Mr. Nkosi alleged that he pursued the matter with the chairperson of the interviewing panel, Mr. Chabalala, who informed him that the then Speaker of the Legislature, Mr. Lubisi, had been summoned to the ANC Provincial Office by the Premier to reverse the decision of the interview panel. We decided to focus on the investigation on whether the legislature irregularly appointed Ms. Memela to the position of Senior Manager Communications and whether the complainant and other candidates were prejudiced by the conduct of the legislature in this matter. We found the allegation to be substantiated, and the conduct of the legislature in appointing Ms. Memela, who only obtained the third position during the interviews, is improper. The argument forwarded by the legislature that the decision to appoint her was taken on gender imbalance principles cannot be accepted, as the legislature should then have appointed Ms. Julius, another female candidate who performed better than Ms. Memela in the interviews. So the allegation that the conduct of the legislature prejudiced the complainant and other candidates for loss of employment opportunities is substantiated. So the findings which we came to was that to remedy this, the Secretary of the Legislature is directed to review and amend the recruitment and selection policy of the legislature. In particular, there's a certain paragraph which had uncertainties, which included terms as etc., because then it created this room for the manipulation of this process. Then the Secretary must also provide training to the staff of the legislature on this, on their policies, and he must ensure that any principles that are to be recognized during the recruitment and selection processes are documented in a form of circulars for future purposes. The sixth report relating to irregular appointment is the appointment involving a certain Mr. Sanke to the position of supervisor, Water Road Mariko by Ramuchere Moilwa local municipality. It was alleged that Mr. Sanke applied for the position of supervisor and included a copy of a school report indicating that he only passed grade 11. And it apparently came to the attention of the complainant that Mr. Sanke was once a chairperson of the GSB school governing body at the same school, and that during his term of office, Mr. Sanke allegedly managed to improperly and or fraudulently use the school documents and reports to fake his grade 11 report. This was, according to the complainant, in order for Mr. Sanke to qualify for the post, which he is currently occupying at the municipality, he needed to have a certain qualification. So we decided to investigate all these above irregular appointments and this post of Mr. Sanke, and we found that the allegation that the municipality irregularly appointed Mr. Sanke was substantiated. And we have made various recommendations and findings to the municipality to also review their recruitment policy, to also make sure that if Mr. Sank, in fact, he is still employed by the municipality, and that is an irregular appointment which the municipality needs to deal with, and they need to report it accordingly to the council, and the municipal manager is directed to put processes in place to terminate that particular appointment. And if there's any unlawful and improper, in fact, on the recovery of the monies which the municipality has spent, they must institute civil claim against those who are implicated and those who are involved. And then the next one relates to, number 7, relates to the complaint we've received against the Independent Police Investigation Directorate. This report, as you know, is already in the public domain. In fact, some of the affected parties have already made pronouncements on it. For instance, I've noted that the former executive director, Mr. Robert McBride, has made a public statement to the effect that he will be taking the report on judicial review. He also did not miss the opportunity to use the tiered defense mechanism of those who don't want to be held to account, calling the findings as part of the so-called Fight Back campaign. For the record, any party that is aggrieved by my decisions is entitled to challenge the matters in court, and on receipt of court papers, we will study the application and establish whether we can defend the matter successfully and whether that has an impact on the mandate of the public protector. Be that as it may, you need to note as well that this is not an own initiative investigation, it's an investigation on receipt of a complaint, and that relates to alleged procurement irregularities, irregular appointment and maladministration relating to and the appointment of a certain Miss T.H. Botha as Deputy Director, National Specialized Investigation Team by the IPID. It was prompted by a complaint lodged in June 2018 by Mr. Mkhwebane. In a nutshell, he made the following allegations: that IPID changed and manipulated the requirements of the post of a Deputy Director in order to suit Ms. Botha without any job evaluation process being conducted by a job analyst as required by the institution's policies. As a result, the complainant who had applied for the job and other qualifying candidates were disadvantaged and prejudiced by this maladministration and nepotism. In essence, the IPID improperly appointed Ms. Botha as a Deputy Director and without following proper recruitment processes. That IPID Labour Relations Desk referred a grievance that resulted from this whole debacle to the Office of the Presidency for further investigation, since the allegations involved senior officials within the IPID. The matter was investigated and a report was with adverse findings for high-ranking IPID officials was produced. However, it was not implemented. He alleged further that IPID improperly suspended the complainant in retaliation against his protected disclosure regarding alleged unethical conduct by Mr. McBride and regarding the grievance against alleged irregular appointment of Ms. Botha, thereby amounting to an occupational detriment as envisaged in the Protected Disclosures Act. In addition to these allegations, on our own, during the course of the investigation, we came across information which suggested that IPID did not follow proper procurement processes when it appointed Fidelity Security Services to provide the services of an investigative analyst for the interpretation of cellular and other data in criminal investigations. Following an analysis of all the allegations and our suspicions as stated above, we decided to narrow the investigation down to the following 4 issues: whether IPID improperly followed procurement processes when it appointed Fidelity Security Services, and secondly, whether IPID improperly appointed Ms. T.H. Botha as a Deputy Director without following proper procurement processes, whether IPID improperly suspended the complainant in retaliation against his protected disclosure regarding alleged unethical conduct by Mr. McBride and regarding the grievance against alleged irregular appointment of Ms. Botha, whether the complainant IPID or any other person suffered prejudice as a result of the alleged improper appointment of Ms. Botha. We found that IPID failed to follow proper procurement processes when it appointed Fidelity Security to provide the services of an investigative analyst for the interpretation of cellular data in the criminal investigation. We also found that IPID improperly appointed Ms. T. Botha as Deputy Director without following recruitment processes. We further found that IPID improperly suspended the complainant in retaliation against his protected disclosure regarding alleged unethical conduct by Mr. McBride and grievance against alleged irregular appointment of Ms. Botha, thereby amounting to occupational detriment as envisaged in terms of the Public Protected Disclosure Act. Lastly, we found that the complainant suffered prejudice in a form of occupational detriment. However, such was immediately addressed by the settlement agreement which he subsequently signed with IPID in the presence of his legal representatives. The IPID also suffered financial prejudice or loss by advertising a post of Deputy Director at the cost of 34,900, which was never filled officially. It was withdrawn and cancelled. The IPID advertised another post for the same amount, and it being subjected to the necessary evaluation as required by the Public Service Regulation. So the expenditure of 102,000 incurred on travel and accommodation for Ms. Botha was not in the approved submission nor approved separately. This in essence understated the actual contract amount of 171,000 which was paid by IPID to this Fidelity company. The travel and accommodation cost of Ms. Botha should have been included in the SLA or service level agreement, but it was not. Clearly, such conduct amounted to irregular expenditure as defined and prohibited in terms of Section 38 and 45 of the PFMA. The IPID appointed Ms. Botha on the 3rd of August 2017 on a salary notch of 657,000 per annum for a post that never existed before and was never subjected to the job evaluation. So Ms. Botha has received a salary from IPID in excess of 1,174,000. Continuous payment of such salary to Ms. Botha amounts to a cumulative or progressive irregular expenditure in violation of the PFMA. To remedy such maladministration and improper conduct, the acting executive director of IPID is directed to take appropriate steps to ensure that within 30 days from the date of this report takes disciplinary steps against all IPID officials who were involved or who were responsible for the violation of the Constitution, IPID Act, the PDA Act, and the recruitment and selection policies of IPID and the SCM policies, supply chain management policies. Investigate and recovers any irregular, unauthorized, fruitless, and wasteful expenditure incurred by IPID from any person who is liable in law, and further 60 days of the issue of this report, all IPID officials who were involved in the SCM process, including senior management, should be trained on the SCM policies and recruitment policies. Within 60 days from the date of this report, he should present this report and the investigation report compiled by Advocate Moloku to the Minister of Police for a decision to address the irregular appointment of Ms. Botha and other findings contained in the presidency report. Let me then indicate that all the above irregular appointments or findings, as the case we've mentioned above, we will be asking all the relevant authorities, or we've asked all relevant authorities to initiate a judicial review process as prescribed in terms of Section 6 and 7 of PAJA to set aside those appointments. The next set of reports deal with other manifestations of maladministration which have nothing to do with staff appointments. Some relate to bread and butter issues, and others relate to procurement challenges in the procurement sector. The first one is my office investigated the allegations of failure by the Tsobotla local municipality which failed to implement its bylaws and the provisions of the National Builders Regulations and Building Standards Act relating to an illegal structure erected in Ekurhuleni in the northwest. So the complainant alleged that the municipality failed to implement its bylaws, and we investigated the matter. And on investigation of the matter, we found that the complaint is substantiated, and then we've directed that the municipal manager should demolish this illegal structure which was in violation of the bylaws within 30 days. And further, the municipal manager should take disciplinary action against the responsible officials. Report number 9 relates to allegations of failure by the Department of Human Settlement to allocate RDP houses to Mr. Sibi and Mr. Mahlangu, who are residents in the Mbeki local municipalities in Mpumalanga. So the complainants allege that they were beneficiaries of RDP houses, but were not allocated these houses that were specifically built for them after their applications, one of which dates back to 1999, were approved. So they allege that they were approved for the Greenfield housing project in Bethel, where their approved RDP houses were built. However, some illegal occupants moved into such houses before the complainants could occupy them. We investigated whether the department unduly failed to allocate the RDP houses that were specifically built for the complainants after their applications were approved, and if the conduct of the department resulted in the complainants suffering prejudice. We found both allegations to be substantiated, thereby constituting improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. So in the remedial action, we directed the head of department to commence with the process of providing the complainants with adequate housing by either evicting the illegal occupants within the prescripts of the law, alternatively securing other houses for the complainants. This should be done within 90 working days on issuance of this report. The 10th report relates to an investigation of irregular awarding of tenders and fruitless and wasteful expenditure by the Mpumalanga Department of Social Development. This followed a complaint by one Mr. Mahlangu, who alleged that 2 tenders for catering and cafeteria services and travel arrangements were irregularly awarded. With regard to the catering and cafeteria services tender, the complainant alleged that the job was awarded to the 3rd highest bidder, who was supposed to have been disqualified on account of not having attached a valid unemployment insurance fund certificate on the closing of the tender. He indicated that the tender in question was re-evaluated and adjudicated to favor the incumbent, and that a member of the bid specification committee also served in the bid evaluation committee. The complainant further alleged that he was suspended pending an investigation after disciplinary hearing. He was found not guilty, and yet the department refused to allow him back to work. This was despite the fact that the department had initially informed him to report back to work. Nevertheless, the department continued to pay his salary at home. So on investigation, we found that these allegations are substantiated. But the one relating to the failure by the department to follow proper procurement processes in awarding the catering and cafeteria services, traveling arrangements, tenders, that one is unsubstantiated. The department was then requested to ensure that the head of department determines the appropriate and reasonable amount which is recoverable, especially on irregular expenditure from Ms. Mlangeni. any other person who's liable. And then the department must also, within 30 days from date of the receipt of the amount certified by the department as recoverable, institute civil proceedings to recover. The 11th report relates to allegation of maladministration, irregular award of tenders, irregular payment of 38 million, irregular appointment of Mr. Ngema, and irregular appointment of private attorneys by Ekurhuleni Metropolitan Municipality. This complaint was lodged by Mr. Mlandu, who alleged that the municipality irregularly awarded a tender for the supply, delivery, and installation of intelligent water meters to Lisira Tech, amounting to 109 million in contravention of the Municipal Supply Chain Management Policy and the Municipal Finance Management Act, in that Mr. Ngema, the former city manager, delegated his powers to Mr. Zakes Mieza, the municipal CFO. The other allegation is that the municipality irregularly awarded a tender for the implementation of the institutional review process, that Mr. Ngema delegated again his powers to Ms. Linda Mtenjane, an external contractor, in violation of the Municipal Supply Chain Management Policy and MFMA, which is Municipal Finance Management Act. Mr. Ngema unjustifiably exercised his powers, intimidated and victimized the complainant for making a protected disclosure. That was another allegation. But then it should be noted that this complaint and the municipality signed the settlement agreement with the intention of finally and wholly resolving this allegation. Therefore, this matter was not investigated. The municipality irregularly paid an amount of 38 million to Lisira Tech in violation of the municipal policies, and further that the municipality irregularly appointed Mr. Ngema, the former city manager, from 2012 to 2016 in contravention of the Municipal Systems Act. After thorough analysis of the complaint, we decided to investigate the following 5 issues. Whether the municipality irregularly awarded the tender to Lisira Tech amounting to 109 million. The second one, whether the municipality irregularly awarded the tender under contract CF10 2011, in that Mr. Ngema improperly delegated his powers to Ms. Linda Mtenjane. And the other issue investigated whether the municipality irregularly made the payment of 38 million to Lisira Tech, and whether the municipality irregularly appointed Mr. Kaya Ngema as the city manager from 2009 to 2016, and whether the municipality appointed private attorneys to represent the municipality, and they didn't follow or in violation of the supply chain management policies. We found that the allegation that the municipality irregularly awarded the tender to Lisira in the amount of 109 million is substantiated. However, the allegation that this happened because Mr. Ngema improperly delegated his powers to the CFO is not substantiated. And the allegation that the municipality irregularly awarded the tender in that Mr. Ngema delegated his power to Ms. Mtenjane, a contractor, this allegation is also not substantiated. The allegation that the municipality made an irregular payment of 38 million before delivery of the goods, this one is substantiated. Because 31 May to 31 July 2011, the CFO approved the amount of this 31 million to Lisira Tech for the supply, delivery, installation of intelligent water meters before the delivery of the meters. The evidence suggests that the delivery of the set meters was done almost 2 months after the municipality effected the payments. And then the allegation that the municipality irregularly appointed Mr. Ngema as city manager from 2009 to 2016 without a written contract of employment is substantiated. Evidence at my disposal confirmed that Mr. Ngema worked as a city manager without a valid contract of employment. And Councillor Masina also considered that Mr. Ngema did not have a valid contract of employment, but that the municipality had a gentleman's agreement of employment with Mr. Ngema for the period in question. The allegation that the municipality irregularly appointed private attorneys and advocates to represent the municipality in internal disciplinary hearings and court cases is also substantiated. In this one, it relates to the attorneys specifically because they didn't have a panel of attorneys. Therefore, that violated the constitution because there was no fairness in how the attorneys were utilized. So the appropriate remedial actions we've taken, that the municipality must, within 30 days of issuing of this report table the copy of the report to the municipal council. The municipal council to discuss and adopt the report and pass a resolution thereon. Within 60 days of issuing of this report, institute appropriate action against the CFO on basis that he acted without due authority. As such, he violated the SEM policy. And then with regard to the attorneys, institute internal audit proceedings to determine the total amount of money paid to the attorneys, and the audit report must therefore be presented to the municipal council. And the next one, within 60 days of issuing this report, the municipality should consider or take legal proceedings to recover from Mr. Ngema the total amount of which was paid to these particular attorneys contrary to the SEM prescripts. With regard to the issuing of to the appointment of Mr. Ngema into the post, in fact, this relates to the issues of the supply chain and whatever, and the recruitment processes. We then request that the officials be trained on the recruitment policies of the municipality. And then the municipal mayor and council must, within 30 days, ensure that a copy of this report is presented to the municipal council and is adopted. The 12th report relates to my investigation against the Department of Agriculture, Forestry and Fisheries in connection with the Farmer Register project. It was alleged that the department, which is now known as the Department of Agriculture, Land Reform and Rural Development, incurred fruitless and wasteful expenditure on the FRP, which is this Farmer Register project, and as a result, funds had to be redirected from other departments within the Department of Agriculture, Forestry and Fisheries to fund the project. So this matter was investigated, and we had the following issues which were substantiated. The allegation that the department irregularly procured rental vehicles for the Farmer Register project was substantiated. The DG, in fact, the procurement of the 50 buggies by DAF amounted to improper conduct as contemplated in the Constitution and constitute maladministration. To remedy this, the DG was requested to, or was directed to take cognizance of the findings of the maladministration, fruitless and wasteful expenditure contained in this report and ensure that mechanisms are enforced or introduced to prevent recurrence of such matter. That the DG must also advise my office of the mechanisms that he will be putting in place, and further that the commissioner, in fact, this is another matter. Then the other issue, report number 13, relates to Inqubaye Temba local municipality pertaining to the misappropriation of public funds. Again, in this particular matter, the complaint was lodged by Desha, a councillor of DA, who alleged that services for the transportation of 60 persons in January 27 from Craddock to Joburg and back were procured at a cost of 45,000 without following procurement processes. And he further alleged that a luxury vehicle was hired for the same trip at the cost of 8,200 outside the supply chain management processes to transport 180 persons to Mthatha, again in January 2017, at the cost to the municipality, which is amounted to 72,000, without following the procurement processes. On analysis of the complaint, we found that all three allegations are substantiated, thereby constituting improper conduct and maladministration. And the remedial action taken in this regard is that the Speaker of the Municipal Council must take appropriate steps to ensure that the Council establishes a special committee to investigate whether the conduct of the Executive Mayor referred to in this report relating to the procurement of transportation constitute a breach of the Code of Conduct for municipal councillors. This must happen within 30 days, working days from date of this report. The municipal manager, on the other hand, must take appropriate action against the officials who were involved in the procurement of transportation without following the proper procurement processes. The report number 14 relates to an investigation of maladministration and impropriety in dealing with incapacity leave of Mrs. Cry by the Department of Education and Sport Development, Dr. Kenneth Kaunda district in the Northwest. The complainant alleged that in September 2015 to July 2016, she applied for incapacity leave and provided the doctor's motivation, but the department rejected her incapacity leave. And the period she applied for was then regarded as unpaid leave and was liable to pay the department for the said period. This is, he regards as unjustified enrichment on the part of the, in fact, they regarded it as unjustified enrichment on her part. The department deducted an amount of 1,172 monthly as reimbursement. And the complainant's contention is that, in this regard, is that the department's decision to deduct the amount from her salary was illegal, unfair, unjust, and unreasonable, and it was based on the wrongful interpretation of the policy or the relevant policy in this particular instance. So the complainant therefore wanted the department to reimburse her the 28,129. We investigated whether the department irregularly deducted this matter, and we found that both the allegations that they irregularly deducted and that she suffered prejudice were substantiated. As part of the remedial action, the administrator must ensure that the 28,000 is paid back to the complainant and must issue a letter of apology. Report number 15 relates to an investigation of improper, proper conduct or alleged improper conduct by the University of Cape Town to provide safety measures against the drowning of Mr. Madiba, improper failure by the South African Police Service to investigate and report on the drowning incident, and undue delay by the National Prosecuting Authority to recommend the reopening of an inquest into the matter. The investigation was a complaint by Mr. and Mrs. Madiba, who alleged that UCT failed to provide safety measures against the drowning of their son. And in March 2016, it was alleged that the UCT or its employees failed to provide safety measures, and also they allowed him to join its rowing club without training or testing his swimming abilities. According to the complainants, the UCT took the deceased to a dam for a swimming practice, and this was done without the provision of the safety measures, such as life jackets, a safety boat in case of an adverse event. Further, the deceased allegedly signed up for indoor rowing, but he was taken in the UCT's bus and made to swim in a dam. When the complainant requested documentation from the UCT proving that the deceased had joined the rowing, and the responsible administrative directors informed them that there was none, until E-News Channel Africa inquired about it, after which such documents proving that he had joined indoor rowing were provided. It has further been alleged that the deceased was not made to sign an indemnity form for indoor rowing, and this was confirmed by Ms. Hall, the then UCT's acting manager of sports. The complainant also alleged that the SABS and NPA unduly delayed to investigate and report on the matter, and that there was no communication from the UCT regarding its intention to investigate the circumstances that led to the drowning of the deceased. On analysis of the complaint, the following issues were identified for investigation. whether UCT failed to provide safety measures against the drowning of the deceased, whether UCT unduly delayed to investigate the drowning incident of the deceased, whether SABS improperly failed to investigate and report on the matter, whether NPA delayed to recommend the opening of an inquest, and whether the complainant suffered prejudice. We found that the allegations that the university failed to provide safety measures against the drowning is substantiated. UCT had no rowing safety measures or rules in place at the time of the drowning as required by Rowing South Africa. UCT only developed and implemented these SOPs as a result of this drowning incident. The conduct of the UCT was in violation of the Row South Africa Constitution and the Code. We also found that the allegation that UCT delayed to investigate the drowning incident of the deceased is substantiated. The UCT only appointed Advocate Mayosi in June 2017 as presiding officer of an inquiry to consider the circumstances, and this was 15 months after the drowning incident, and the report was only produced in June 2018, 2 years, 3 months after the incident. UCT's conduct was in contravention of Section 195 of the Constitution and the Batupili Principles. We found that the allegation that SABS fails to investigate and report on the drowning of the deceased is not substantiated. My investigation revealed that SABS properly opened the inquest docket. A formal inquest hearing into the circumstances leading to the deceased was convened, and the magistrate found that the likely cause of the death was drowning while swimming in the dam. The court further found that the death was not brought about by an act or omission involving or amounting to any person. IPID also investigated alleged improper conduct by SABS and found that an inquest docket was properly opened instead of a culpable homicide. We found that the allegation that NPA delayed to recommend the reopening of the inquest into the death is substantiated. I wrote to the NDPP to consider recommending to Minister, because the Inquest Act allows that, in that the prior inquest was not a formal inquest, but it was an informal inquest. Therefore, the Inquest Act allows that the NDPP can request the Minister to reopen the inquest so that they can conduct a formal inquest. And the meeting we held with the NDPP, that was the arrangement and the agreement, and there was a finding against the NPA for contravention of Section 195 of the Constitution and the Batupili Principle, in that they delayed to do or to reopen the matter. And we further found the UCT, the allegation that the complainant suffered prejudice was substantiated. The complainant submitted that they are distressed by the fact that their son, a young man, promising student, drowned at the dam whilst being under the care of UCT. I think on this one we had an engagement with the UCT, which also was very detailed when we engaged with them, that most of the students, especially at universities and all the students are the ones, because they are now regarded as adults, they are the ones who enter into a contract with the universities. And our finding in this particular matter was that the UCT should come up with a policy, which they have done, and I must indicate that they have implemented all our remedial action, and the remaining one was the recommendation we've made on the ex gratia payment, especially because the university promised to pay for the family to travel to Cape Town when they had a memorial service at UCT. So that's the remaining one which they need to implement. Lastly, the National Director of Public Prosecution should consider submitting a recommendation to the Minister within 30 days to consider reopening the matter, at least for a formal inquest, so that the family can understand what transpired on the day in question. Report number 16 relates to the Vukile Learnership Program by National Department of Public Works and Gauteng Department of Infrastructure and Development. The investigation was lodged or was prompted by a complaint lodged by Mr. Adam Mahlangu and others in April 2016. It was a group of 20 companies participating in the incubation process program known as Vukupile Learnership Program for a period of 3 years by the Gauteng Department of Infrastructure and Development and the National Department of Public Works. They alleged maladministration, favoritism, lack of accountability, and inappropriate use of funds allocated to this Vukupile program. According to the complainant, the Vukupile program is meant to uplift upcoming construction companies, and it was supposed to be delivered in 3 phases. However, the phases were not implemented as planned. They allege that other companies were treated with favoritism as they were not awarded work in accordance to the program. And for example, companies with low grading, as per the Construction Industry Development Board, seemed to be awarded projects amounting to 3 million, while companies qualifying for higher amounts were awarded tenders of lower amounts. The complainant further alleged that the implementation of the training project was delayed and the project was finally allocated. It was not in line with the EPWP guidelines. Further, that in terms of the EPWP guidelines, they were to be allocated project in accordance with the following phases, which never materialized. Phase 1, the minimum was 500,000. Phase 2, the minimum was 750,000. And Phase 3, the minimum was 1 million. We've investigated the matter according to the issues which we've identified, and we found that all 3 allegations were substantiated, and we've made the recommendations to the department that in accordance with the memorandum of agreement which was signed between them and Public Works for a period of 4 years commencing in January 2019 to 2022 May, the Gauteng Department of Infrastructure Development will progressively allocate work to the complainants and will assign projects to the complainants, and after having assisted them with the statutory compliance such as tax compliance, assign work to them and further provide necessary mentorship according to the requirements of this program. Report number 17 relates to the investigation of improper conduct in connection with the appointment of a service provider by the Department of Labour, as well as allegations of maladministration, corruption, and fruitless and wasteful expenditure and the misuse of investment money by the compensation fund. The investigation was prompted by a complaint from Mr. Bantu Holomisa, an MP and leader of UDM. He alleged that maladministration and corruption by the Department of Labour in connection with the irregular appointment of Accenture, specifically alleged that Accenture, a management consulting and technology and outsourcing services company, was appointed to provide IT capability, leverage, expertise, and specialized knowledge to the department. The former Minister of Labour, Ms. Oliphant, enjoyed a close relationship with one of the directors of the South African division of Accenture. That's the allegation. There existed a corrupt relationship between the former minister and her close relative in awarding the tender, that the former minister did not declare her relationship with Accenture. He also alleged that there was maladministration in connection with the appointment of new integrated credit solutions by the compensation fund, and as a result, the compensation fund incurred fruitless, wasteful expenditure. Specifically, he made the following allegation: that the compensation fund appointed an external debt collector, NIX, but despite this, the debtors book increased from 3 billion in 2010 to 8 billion in 2013. In addition, it was alleged that the contract awarded to NIX was deliberately manipulated and unilaterally changed as the initial specifications, whereby NIX was supposed to only collect debt older than 180 days were deviated from. In this respect, it was further alleged that there was a duplication of tasks or duties by this company and the employees of the compensation fund. That the former commissioner, Mr. Shadrack Mkhonto, ignored the legal advice from senior counsel that the contract with NICS should be terminated on the basis of poor performance. Mr. Olumisa alleged that compensation fund was misusing investment money as it allegedly intended to transfer 2 billion to the Department of Agriculture, Forestry and Fisheries under the guise of a social responsibility investment in order to fund further development projects which were not related to injuries on duty. In addition, it was alleged that management of the compensation fund had no plan to achieve financial returns of the said investment. Lastly, he alleged that the former commissioner, Mr. Mkhonto, authorized advance payments to private companies to the tune of 546 million without the necessary invoices to reconcile the payments. In view of the above allegations, my office identified the 3 issues to investigate: whether minister had a duty to disclose a relationship with an employee of Accenture at the time when the department conducted a business with Accenture, and if so, whether such failure constituted improper conduct, whether there were irregularities in the award, extension contract, management of the debt collection and debt management control center services, and whether the former commissioner authorized advance payment to medical service providers without necessary invoices to reconcile the payments, as a result of which the compensation fund incurred irregular expenditure. We found that the allegation that the former minister of Labour had a duty to disclose her relationship with an employee of Accenture at the time when the department conducted business with Accenture is unsubstantiated. The former minister failed to manage. There was a perception that the former minister failed. I think in your document it says substantiated, but in the report it's unsubstantiated, because the minister, when the minister joined the department, the son was already working in for that company, and the minister was not involved in the procurement processes, because that was the responsibility of the director general as the accounting officer. So, and then we also found that the allegation that there were irregularities in the award, extension and contract management of bid services, as a result of which the compensation fund incurred fruitless and wasteful expenditure. This one is substantiated. The initial award of the contract was irregular because the establishment of the DMCC was descoped, and the compensation fund agreed to the handover of debt which were 60 days and older without prior approval of the bid adjudication committee. In addition, the commissioner could not award the contract as the value of the contract exceeded his financial delegation, which is 30 million. The conduct of the compensation fund to award this tender was in contravention of their supply chain management policy, and further that the commissioner awarded this contract, he exceeded his financial delegation. The data required was given to in CSV format, and no interface was established between systems. In fact, this relates then to how the contract was managed. As a result of irregular award, the compensation fund incurred an irregular expenditure in the amount of 213,240,000, being the total amount in commission paid to NICS for a period of 3 years, as held in the arbitration award. So the deviation from competitive bidding process was in violation of the National Treasury Instruction Note 31, Instruction Note of 31 May 2011. In terms of which it was required that National Treasury's approval must be acquired for the extension above 10 million in addition, and this could not have happened if there is an could not extend the contract to the value of 15 million or 15%. This was in violation of the National Treasury regulations. The conduct of the CF or compensation fund in extending the contract with this company constituted proper conduct. and as a result, failure by the compensation fund to conduct due diligence prior to the awarding, and the failure by the compensation fund to exercise proper contract management over the contract awarded to NICS, which incurred this fruitless and wasteful expenditure in the amount of 349,159,000. So the compensation fund incurred all this fruitless and wasteful expenditure. The former commissioner failed to ensure effective, efficient, economical and transparent use of financial or other resources of the compensation fund. The conduct of the former commissioner, Mr. Mkhonto, was found to constitute improper conduct. We further found that the allegation of the former commissioner authorizing or an advance payment to these medical service providers without the necessary invoices to reconcile the payments, as a result of which the compensation fund incurred irregular expenditure, is substantiated. By its own admission, the compensation fund advanced payments to 5 service providers to the amount of 456,866,000. These payments were made in contravention of the National Treasury regulations and the supply chain management policies. So the findings in this particular matter is that we've sent the report to the President as far as Minister Oliphant is concerned, to the Minister of Employment and Labour to take cognizance of the report, and the Director General of Labour must, within 15 days of the date of this report, take cognizance of the findings and take action against the relevant officials. And further, that the Director General must report to National Treasury the particulars of irregular expenditure mentioned in the report, and the Director General must initiate processes to recover any irregular and fruitless expenditure. And the Compensation Commissioner must, within 60 days from date of this report, evaluate the effectiveness of the compensation fund's internal controls on supply chain management processes. This is obviously a summary of each of the reports we are releasing. The full reports can be found on the website. There are a few other reports that are not in this statement, but you will find them on our website. I look forward to the full implementation of the remedial action in all these reports. In this sense, I implore organs of state and state functionaries to take the findings and the related remedial action in these reports in the spirit of working together to resolve governance lapses and to avoid recurrence in the future. So our role, as you know, is to strengthen constitutional democracy and not to be antagonistic towards government. And our investigations are evidence-based. We are not thumb-sucking these findings, but we have these findings based on our investigations. Thank you for your time.
Thank you, Public Protector. Colleagues, I will now open the floor for questions. We'll take them in batches of 5 at a time, and allow the Public Protector and fellow panelists to respond to all those queries. And then if there are further questions, we will then entertain those. I don't see any hand opening. I see 2 hands here. I'm not sure where our assistant is for the rolling mic to make it around the room. Okay, let's start with the 2 gentlemen over here, because there are no other hands. Let's start with Pule.
Good afternoon, PP. Just one question for me. My name is Tshwete from ETV News. So, just to understand this correctly, are you basically saying that the Court got it wrong, that Batabile Tlamini do not do anything wrong? Are you saying that the decision against her was absolutely wrong? Thank you.
Hi, PP. Lindobuhle Tulu from ENCA. You might be sounding silly, but I'll risk it. I just want to find out if you've, in the process of, compiling this, did you take out your calculator, particularly on the first section, and count how of the money is going to be declared as irregular expenditure because of the appointments or irregular appointments as said. Thank you.
Thank you. Are there any more questions? Oh, okay.
Good afternoon to the public protecting the panel. My name is Ekurhuleni from Bloomberg News. PP, just point of clarification. In the report pertaining to Minister of Labour, then former Minister of Labour, Mr. Elephant and Accenture, in your remedial action, you say the President must take cognizance of findings of improper conduct. I'm not sure if maybe I've misread the report, but did you not say there was no finding of improper conduct? So should we then just ignore that particular finding? And then also, in recent weeks, the parties in Parliament have essentially established or agreed on a process for the removal, potential removal, of heads of patronage institutions, including the Public Protector's Office. We know that there was a bid at some point calling for your removal. Have you been contacted in terms of any process that may be undertaken pertaining to that particular application that was brought before Parliament by the DA?
Okay.
Sorry, Councillor, just one last one. Really tricky once again. So, organization, just accountability has launched an urgent bid. I think it was 5 days ago where they said that the High Court should have a decision to declare you unfit to hold office. Will you be responding to that? Is there anything that you'll be saying about that as well? Thank you.
Thank you. And last one.
PP, hi, my name is Jeanette Chabalala from News 24. I just wanted to get your reaction on the Constitutional Court's decision to refuse you pulling out of the appeal on the Gordon matter. Thank you.
Thank you. Over to you, Public Protector.
And thanks, Bule. I'm not saying the Concord is wrong. I think if you can read the statement, I said the complaint was lodged that Batabile misled Parliament. So what transpired is that there was evidence proving that she only became aware of that Sassa is not going to be managing to perform their function only in October 2016. And I am acknowledging in this statement or in the report that the Concord indeed found against her as far as what transpired during the inquiry by Judge Mkhwebane and relating to them not complying to the directives of the Constitutional Court. So that does not have any bearing on the complaint we were investigating. So the complaint we were investigating was misleading Parliament in terms of the Executive Members Ethics Act. So if you can read I'm not contradicting, or I'm not saying the Concord was wrong. I'm acknowledging it that was their finding, which has nothing to do with misleading. Then Lindo Gutle, the calculator issue, the irregular appointments. In each report, we are indicating, remember, if a person is appointed irregularly and they are paid a certain salary, that amount will have to be calculated to determine for the period they've been employed, this is the appointment, the amount which they've spent as an institution. Therefore, that is irregular. They need to declare it to National Treasury, to Council, and as well, I even said, those irregular appointments, the law allows that they need to take them on review. So, and where there is any negligence on the part of the accounting officers or whoever is involved, they need to initiate civil proceedings to recoup those monies. So that's what we did as an institution. So the Bloomberg question, the former minister, yes, when you depend on your team to prepare a statement for you, there will be such instances, and there's nothing which the president will have to do about improper conduct, but then the president should just note the report, because our reports should be used to also be educational to other ministers. It's purely that. And then on the issue of the removal of the Chapter 9 institutions, I have not yet been contacted. I am only reading in the news like yourselves. So we will respond as soon as also I'm given an opportunity to respond if there is any opportunity which will be given to me as the public protector. On the issue of being unfit to hold office, the application by Mr. Hoffman, that we are opposing, and we are going to be filing our papers soon. And then the issue of News 24, the Concord refusal. That process was at the stage of the registrar, but then we will comply with the request, and then we will appear. We will put our position there, because all the other parties agreed that we withdraw, because it was only within 5 days after we've launched it, and then after changing the strategy, we then requested to withdraw. It's only the president who wanted us to proceed. But we will deal with that matter when we appear on the date set. Thank you.
Thank you, Public Protector. Are there any more questions, colleagues? It appears that there are no questions. Let me just say that there's one report that you do not have there. We have asked colleagues to make it available before the otherwise all other reports will be on the website immediately after the press conference. Thank you so much for being joined us, and therefore I adjourn the press conference.
You don't have any comment? No. About your relative was implicated? You can speak about femicide issues, condemnation, and the subjects to translate. Forget about all the mechanics. Excellent. Going to